Hello everyone. My name is Sampa Garmkar Singh. I am Assistant Professor at the WBNEJS, Kolkata. Today we are going to discuss one very important topic, that is Muslim inheritance and succession. Introduction. Muslim law of inheritance and succession can be traced to rules of succession found in the Holy Quran or in the traditions, pre-Islamic customs which received approval of the Prophet. Muslim succession is based on the pre-Islamic customary law of succession and on the patriarchal form of family. Kinds of succession. Succession is of two kinds. First is intestate succession, another is testamentary succession. Let us first discuss about what is intestate succession. When a person dies without making a valid will, based on the religion of the deceased, the property owned by him or her is distributed following the common law of descent applicable under his or her personal law. It is also termed as hereditary succession. Under Islamic law, there are two sects, Shia and Sunni, and both have different rules related to intestate succession. We'll discuss the same. Even in case of testamentary succession, the rules are different. What is testamentary succession? When a person dies, leaving behind a valid will that states how his or her assets and property should be distributed after his or her death. Under Muslim law, a Muslim can make a will to the permissible extent of one third of the entire property. So this makes the Muslim law even more interesting because in another religion, you can have 100% disposal through a will. But if a person belongs to Islamic community, he or she can only make a will up to the permissible limit of one third, not the entire property. Coming to the Shia and Sunni systems of inheritance, there are some notable differences in Shia and Sunni systems of inheritance. In 2018, the Law Commission of India came up with the consultation paper on reform of family law, where all the personal laws were discussed thoroughly. The last chapter of this consultation paper deals with inheritance and succession. The interesting thing is that if you go through this consultation paper, which is from the Law Commission of India, you will find that it talks about all the religion, Hindu, Muslim, Christian, Parsi, and about their inheritance laws. Coming to Sunni law of inheritance. Under Sunni law, there are two classes of successors who are entitled to inherit. First is relations by blood and marriage, consanguinity and affinity. Affinity refers to relationships created through marriage, while consanguinity refers to blood relationships. Second category is unrelated successors. The relations by blood and marriage, they are again subdivided under heirs by affinity, which includes wife and husband, and heirs by blood relations, that is father, true grandfather, mother, true grandmother, daughter, son's daughter, full sister, consanguine sister, uterine brother, uterine sister. And the second category, as we discussed in the earlier slide also, is the unrelated successors. Relations by blood and marriage are further subdivided into three classes. Class 1 is the Quranic heirs. Now, when we talk about Sunni law, the Quranic heirs are described and divided into 12 relations who have their prescribed shares. Class 2, it is related to agnatic heirs, also referred to as residuaries. All male agnates and four females who are sharers but are converted into residuaries in some cases. Let us give you one example here. Daughter is a Quranic heir and she has a prescribed share also. But in the presence of a son, she becomes a residuary and she gets half what the brother is getting. So if suppose it's a son and daughter, so son will get twice and the daughter will get half what the son is getting. Coming to class 3, that is uterine heirs, that is distant kindred, all other blood relations. The Quran deals exhaustively with the law of inheritance. The very first class consists of certain close relations of the deceased to whom a specific share is allotted. The shares are fixed and class 1 heirs take precedence over the other two classes. However, the rule must not be conceived as creating a preferential class of heirs that takes the bulk of the property. On the contrary, on perusal of usual cases, it is found that from the whole of the property, a slice is taken out as per the dictates of the Quran, and the residue, mostly being the bulk of the property, goes to the heirs and residuaries. The Quranic heirs consist mainly of females, barring a few exceptions. The bulk of the property in most cases is thought to be kept intact for the second class, who are mostly all males. Let us give you one illustration to understand the unequal share of the husband and wife. If a woman dies, leaving children or agnatic descendants, the husband is entitled to one-fourth of the net assets. But if there are no children, then the husband gets half of the net estate. However, the wife inherits one-eighth if there are children, and in the absence of children, she gets one-fourth. In case of plurality of wives, the one-eighth or one-fourth share, as the case may be, is equally divided between them. As you all know that under Islamic law, a person may have a maximum 4 wives, and that is permitted. Fluctuating shares of daughter. We discussed in the previous slide as well that daughter receives half in case there is one daughter, and she gets two-thirds in case two or more daughters, they have to inherit it collectively. However, if the daughters coexist with the son, she is made an agnatic heir or a residuary. When a parent is survived by one or more sons, the children, including the daughters, act as agnatic or residuary heirs, giving the sons twice the share of inheritance as that of their sisters. Coming to the third category, distant kindred. In the absence of Quranic heirs and agnatic heirs, the inheritance passes to the distant relatives. Distant kindred are either female relatives or relatives tracing their relationship to the deceased through a female line. Coming to Shia law of inheritance. The Shia law divides heirs on two grounds: heirs by consanguinity, nasab, that is heirs by blood relationship, and heirs by special cause, shabab, that is heirs by marriage, that is husband and wife. So affinity and consanguinity they recognize, but there is no concept of recognizing the distant kindred under the Shia law of inheritance. Heirs by consanguinity. Heirs by consanguinity are further divided into three classes. Class 1 is parents and children and other lineal descendants, how low soever. Class 2 consists of grandparents, true or false, how high soever, siblings and their descendants, how low soever. Class 3 consists of paternal and maternal uncles and aunts of the deceased, and of his parents and grandparents, how high soever, and their descendants, how low soever. Heirs by special cause. Heirs by special cause are divided into two kinds, that is heirs by marriage and heirs by special relationship. Difference in Shia and Sunni laws. It is interesting to note that the starting point of both systems is the immutable text of the Holy Quran. However, the Sunni system of inheritance and the Shia system of inheritance differs widely. Sunni and Shia interpreted Quranic law from different perspectives. Right to dispose of the property during lifetime. The rules of inheritance apply to property owned by the deceased only at the time of death or at the time he enters his final sickness. Until then, the proprietor is free to dispose of the property inter vivos, between living people. Inter vivos actually means from a living person to a living person, as he wishes, through gift or sale, etc. So one example of inter vivos can be a gift. You have to give a immediate delivery of possession in case of inter vivos transaction. But when we talk about a will, It is after the death of the testator. Testator means the person who is making the will. No right by birth. The concept of co-partnership property, unlike Hindu law, is not recognized under Islamic law. Therefore, there is no right by birth in the property. Spes successionis. Spes successionis is a Latin term which refers to the expectation or hope of an heir to inherit property upon the death of another. Let us take one illustration to understand the concept of spes successionis clearly. Suppose X is the father and Y is the son. During X's lifetime, Y has no birthright over the property and Y has a mere spes successionis, that is a chance to succeed to the property depending upon two situations. First is Y survives the father, means before Y's death X has already died, and second is there is property available for succession. So if suppose X has sold his entire property, in that case the transaction has already taken into effect inter vivos. In that case there is no property to be inherited by Y. Murderers disqualified. Homicide. A person who causes the death of another person cannot inherit his property by inheritance or even through testamentary succession. So this is a restriction, a bar. However, when we look at the Sunni and Shia laws, they have the different interpretation. The rule is applied strictly when we talk about Sunni law, irrespective of the fact whether the death was caused intentionally or even accidentally. But under Shia law, the disqualification is operative only where the death was caused intentionally. Means if there is any accidental death, in that case, the person is not disqualified from inheriting the property of the person whose death he has caused, but accidentally and not intentionally. And in Sunni law, whether it is intentional or accidental, no matter, it is a strict prohibition. Coming to the rights of illegitimate children. An illegitimate child is one that is born out of a lawful wedlock. If a woman gives birth to an illegitimate child, not only would the child be excluded from inheritance, but also the woman would be punished for zina, that is illicit intercourse, because Islam does not permit sexual relationship outside marriage. Under Sunni law, an illegitimate child is deemed to be related to its mother and inherits from her and her relatives, but does not inherit from the father or any of his relatives because the child is born out of a lawful wedlock. When we talk about the Shia law, generally an illegitimate child neither inherits from any of the parents nor any of their relatives. And it is very pathetic because the child is not at fault, but he is the one who is getting the punishment for being an illegitimate child. Coming to doctrine of rad or return, the eligible Quranic sharers are given their fixed share first, and the residue left passes to the residuaries. If there is no residuary, then the residue in the presence of the sharers does not pass to the distant kindred, but comes back or returns to the sharers, and they are entitled to take it in proportion to their shares. This coming back of the property to the sharers is known as the doctrine of return or doctrine of rad. This rule is subject to one exception, that is the surviving spouse, whether the husband or the wife is not entitled to take a share from the return or rad, so long as any other sharer or even a distant kindred is present. Coming to doctrine of rad, some more clarification is again, it is required to know this concept properly. If only the husband and a distant kindred are present, that is son of a predeceased daughter is present, then the husband will take half as there is no child or child of a son as a sharer, and the remaining half will go to the son of a predeceased daughter who is a distant kindred. But if no heir is present and the deceased dies leaving behind only a widow, Then in such circumstance, she would take 1/4 of the property as a sharer because Quran provides that division, and she will take the rest, the remaining 3/4, under the doctrine of return or rat because there is no other person present. Another doctrine is doctrine of increase or doctrine of owl. The sharers are entitled to the property in fixed shares. It may happen sometimes that the sum total of the shares exceed the heritable property. The shares of each of them are proportionally deducted. To apply the doctrine of owl, the denominator is increased to the numerator so that the shares of all together equal unity or the heritable property. Coming to the table of Sunni sharers, male sharers. First we take note of what the husband gets. So, husband receives 1/4 of the share in the presence of a child or child of a son, how low soever, and half in the absence of a child or child of a son, how low soever. Father receives 1/6 of the share in presence of a child or child of a son, how low soever. The father inherits the same share as a residuary in the absence of a child or child of a son, how low soever. True grandfather receives 1/6 of the share in the absence of the father or a nearer true grandfather. So here the interesting thing is that the table, if you go by the Sunni sharer list, if you read that, you will find that it provides that how much share and which is already fixed will be given to them. However, there are certain variations and it depends upon different circumstances that sometimes the sharer also inherits as a residuary. Like in this case, the father, his example I have given you. Now, when we talk about true grandfather, it is in the absence of father only the true grandfather will come into the picture and he will get the property. If suppose father is present, then in that case father will receive the 1/6 of the share, not the true grandfather. True grandfather only will inherit if father is absent or a nearer true grandfather is absent. Coming to female sharers, wife. She receives 1/8 of the share in the presence of child or child of a son, how low soever, and 1/4 in the absence of a child or child of a son, how low soever. If the number of wives is more than one, because Islam permits 4 wives at a time, then all the wives will share equally from the share which is provided to them. So it can be either 1/8 if the children are present, and it can be 1/4 if the children are absent. Second is daughter. Daughter receives half of the share if she is the only daughter. Suppose single daughter, she will get half of the entire property, and 2/3 if there are two or more daughters in the absence of a son. In the presence of a son, she becomes a residuary and takes a share equal to half of her brother's share. As I said, the son will always get double what the daughter gets, and she will always get a half share. So if brother is getting 6 lakh rupees, then the sister will get 3 lakh. Daughter gets half of what the son gets. Another category of female sharers is mother. Mother receives 1/6 of the share in the presence of a child or child of a son, how low soever, or two or more brothers or sisters, or even one full consanguine or uterine brother and one such sister. 1/3 in the absence of a child or child of a son, how low soever, and not more than one brother or sister, if any. But if the wife or husband and the father is also present, then 1/3 of what remains after deducting the shares of the spouse. Full sister also is a female sharer. She receives half of the share if she is the only full sister, and 2/3 if there are two or more full sisters in the absence of a child or child of a son, how low soever, father, true grandfather, or full brother. In presence of a full brother, she becomes a residuary, and again she will get half what the brother is getting. True grandmother, she receives 1/6 of the share a maternal true grandmother takes in absence of a mother, and a nearer true grandmother and a paternal true grandmother takes in absence of mother, father, a nearer true grandmother, and an intermediate true grandfather. Female sharers, consanguine sister, half share if she is the only consanguine sister, and two-thirds if there are two or more. In the absence of a child, child of a son, how soever, father, true grandfather, full brother, full sister, or consanguine brother. When there is only one full sister and she succeeds as a sharer, the consanguine sister, whether one or more, will take one-sixth if she is not otherwise excluded. With the consanguine brother, she becomes a residuary. Uterine brother and uterine sister. One-sixth share when only one heir is present, one-third when two or more heirs are present. In the absence of a child, child of a son, how low soever, father or true grandfather. So here in all these illustrations in the table, you will see that it talks about child or son of a child. So, sorry, it says child or child of a son. It does not consider child of a daughter. So that is very interesting that you will find that it is very patriarchal in nature. Son's daughter how low soever, half share when only one heir is present, two-thirds when two or more heirs are present. In absence of a son daughter, a higher son's son, higher son's daughter, or an equal son's son. In absence of a son, higher son's son, or an equal son's son, and when there is only one daughter or higher son's daughter, the daughter or higher son's daughter will take half, and the son's daughter, how low soever, whether one or more, will take one-sixth. Let me give you one example. Suppose X is a Muslim man. He dies leaving behind his widow and a son. In that case, the widow will take one-eighth share because there is presence of a child, there is a son. So her share will be one-eighth, and the son will take the remaining seven-eighth of the share as a residuary. So sometimes people get confused that Quranic heirs they get preference, but it is just a slice of the cake. The entire cake is given to the agnatic or residuaries. Second illustration is X, a Muslim woman, dies leaving behind her husband, a daughter, and a son. Here the husband will get one-fourth of the share. The remaining three-fourths will be shared by the son and the daughter as residuary, because in the presence of the son, daughter becomes a residuary. The daughter will get half what the son is getting. So the share of the daughter would be one-fourth, and the son will get half of the entire share. So here the share, if you see, is half the son will get, one-fourth the husband will get, and one-fourth the daughter will get. Next illustration is, suppose X, a Muslim man, he dies leaving behind two widows, father and a full sister. So here, two widows, they will collectively take one-fourth because there is absence of a child. So in the presence of child, the widows, they get one-eighth of the share. In the absence of a child, they get one-fourth the share. So their share, they are collectively, they will get one-fourth of the share. So their individual share would be one-eighth each. The full sister will get nothing as she is excluded in the presence of the father. So if father is not present, in that case, full sister will inherit. But in this case, the presence of father has excluded the sister from inheriting anything, and father will take the remaining three-fourths after the share of the widows. He will get the remaining entire three-fourth share as a residuary. So as I was telling you that it is just a slice of the cake, the entire cake goes to the residuaries. Coming to Shia classification of heirs. Shia divide heirs into two groups. First is sharer and second is residuaries. There is no distant kindred category under the Shia law of inheritance. Now there are 9 sharers in the Shia law. If you go by the share table of sharers, there are 9 sharers including 3 male and 6 female sharers. Sharers include parents, including father and mother. Surviving spouse means husband or wife, daughter, full sister, consanguine sister, uterine brother, and uterine sister. Shias do not recognize the doctrine of owl or increase. Here, if the sum total exceeds unity, the excess share is deducted from the share of the daughters or full or consanguine sisters, means from the share of the female relatives. Coming to doctrine of estate, suppose nobody is there to inherit the property. On failure of all the heirs, the property escheats to the government. So on the owner's death without legal heirs, the government takes over the property. This ensures that no property is left without ownership, no property is ownerless, and that it is put to public use. Coming to testamentary succession, that is wills or wasiyat. A will is a legal instrument through which an owner of the property makes a disposition to take effect after his death, and it is revocable in nature. The distinguished feature of a will are it takes effect after the death of the testator. Testator is the person who is making the will, and second is its revocability. So the will can be revoked by the testator anytime by a formal cancellation, or it can be automatically revoked by executing another will of the same property. The latest will be taken into consideration. Essentials of a valid will. The first essential is competent testator. The testator should be mature and of sound mind. Second is competent legatee. The legatee must be competent to hold property. The sex, sect, or religion of the beneficiary is immaterial. A person who renounces Islam and embraces another religion is not a competent legatee. But if a person he belongs to another religion, suppose he has taken birth as a Christian, then in that case they can be a competent legatee. Third is valid subject matter of the bequest, that is owned by the testator and which is capable of being transferred. The property must be into existence at the time of the testator's death. And the last point is bequest to be within the permissible one-third limit, as we have discussed in our discussion today, that a Muslim is permitted to make a will of only one-third of his property. Now, one question which might come to your mind is, why this one-third limit? So, the answer is that the permissibility of bequest up to one-third is traced to a hadith of the Prophet, where Prophet cautioned that one can leave only one-third of his property by a will or wasiyat, and it is better that one leave his legal heirs rich than in a state of poverty, which might oblige them to beg from others. There should be minimal disturbance as far as the laws of inheritance are concerned. So a will cannot be made exceeding the one-third limit in general cases. There are two exceptions to the one-third permissible limit. The first exception is when the testator does not have any legal heir, the testator can make a bequest of the total property in favor of whoever he wishes. Because if he does not make a will of his 100% property in such a scenario, in that case, after his demise, the doctrine of estate will be taken into effect and the government will hold the property, will get the property. So, that's why in such circumstance where there is no legal heir of the testator, he is permitted to make a bequest of his entire property. The second exception is where the heirs themselves consent to the bequest in excess of the one-third permissible limit. So suppose one-third property, the person want to make a bequest of in excess of one-third. In that case, he is encroaching upon the fixed share of the other sharers, other legal heirs. So, in such cases, the consent from these legal heirs are important. And if they consent for this bequest, in that case, it can be even in excess of the one-third permissible limit. Otherwise, it is not possible. However, the Shias and Sunnis have their different laws. But in both cases, in both Shia and Sunni sect, if any bequest is in excess of one-third, then the consent of other legal heirs is a mandate. Coming to formalities for making a will. There are no specific formalities for making a will. A will can be in written form, which is known as wasiyatnama, or it can be a oral will also. But the important thing is that the intention of the testator should be clear and it should not be ambiguous, whether it is through a written mode or orally it has been done. The intention of the testator that he wants to make a will should be clearly reflected and there should be no ambiguity. Coming to Sunni law, it is related to rule of proportionate deduction. In Sunni Muslim law, the rule of proportionate deduction, which is also known as ratable distribution, it ensures that if a will leaves more than one-third of the deceased property to non-heirs or strangers, the gifts are reduced proportionately so that the total bequest does not exceed one-third. This principle ensures that the deceased legal heirs receive at least two-thirds of the estate. So there can be a possibility that a person has made a will of more than one-third of his property. Now, in such case, the property will be, as he is permitted only to make a will up till one-third permissible limit, so that much will be divided amongst the people who are getting the property through the will. Let me give you one example. Suppose X is a Sunni Muslim and he dies leaving behind net assets worth rupees 1,80,000 rupees and a legacy under which he gives rupees 30,000 to A, rupees 60,000 to B and 90,000 to C in that order. Now here the total assets is 1,80,000. Now a Muslim is permitted to make a will of only one-third of his property. So first you divide this 1,80,000 rupees into three parts. So if you make the one-third, if you calculate it, you will find it is rupees 60,000. Now he has made a will of more than 60,000, like 30,000, 60,000 and 90,000. So here the Sunni Muslim will apply the rule of proportionate deduction. So you could see that it is 1 is to 2 is to 3, that ratio it has been distributed. So this 60,000 is the one-third permissible limit. And now you have three people on whom you have to calculate and give them their share. So A will get, after calculation, 10,000 rupees, B will get 20,000 and C will get 30,000 rupees. When we talk about Sunnis and the law related to bequest in favor of an heir. So an legal heir is a person who is competent to take the property of a deceased in accordance with the rules of inheritance. Interestingly, under the Sunni law, a bequest in favor of an heir can not be made even to the extent of the permissible one-third limit, except when the other legal heirs they have given their consent in favor of such a bequest. The reason behind this rule is that it would otherwise enable an heir to take a greater portion of the total property than what is provided under the Holy Quran. Now let me give you one example. Suppose the son's share, suppose the daughter's share is half. Now if she is getting one-third through will also, then her property, her share will be increasing and that will overpass the total property which has been provided to her under the Holy Quran. So that's why wherever there is an excess of this one-third limit, the consent from other legal heirs is mandatory. In general, it is prohibited that in favor of a legal heir, a Sunni Muslim cannot make a will until unless the consent of other legal heirs are given. So this is something which is different in Shias and Sunnis, because Shias, they don't need consent up till the limit of this one-third and they can make a will even in favor of a legal heir. Let me give you one illustration here. Suppose X, a Sunni Muslim, he dies leaving behind net assets worth rupees 6 lakh, and a legacy under which he gives rupees 2 lakh to A, who is his daughter, and 2 lakh to B, who is his best friend. His son and other legal heirs refuse to confirm the bequest. Now here you could see that the total asset is 6 lakh and one third of 6 lakh is 2 lakh rupees. So under Sunni law, the bequest in favor of the heir, in this case the daughter is a legal heir, is not valid unless it is consented by the other legal heirs. And here the other legal heirs, they have refused to confirm the bequest. So in such a scenario, the daughter will get nothing. And as the permissible limit is of one third is rupees 2 lakh and he has made a will of 2 lakh in favor of his friend also, so the friend will get the entire 2 lakh rupees. Coming to the Shia law. Shia, they follow the rule of chronological priority. Now what is chronological priority? It is the chronological order in which order the names has been written. So in the context of Shia law, it specifically dictates that when there are multiple bequests in a will, the ones mentioned earlier in the will take precedence over those listed later. This means the first legatee or beneficiary will receive their share first, and then the remaining portion will be distributed to the next legatee, and so on, until the one-third limit of the total asset is reached. Let me explain it with the help of an illustration. X is Shia Muslim. He dies leaving behind net assets worth rupees 3 lakhs, and he has left behind a legacy under which he has given 50,000 to A, 40,000 to B, and 30,000 to C in that order. So the total assets is 3 lakhs and one third of 3 lakh is 1 lakh. Here, if you apply the rule of chronological order, he has given 50,000 to A first. So A will get the entire 50,000. Then he has given 40,000 to B. So B will also get the entire 40,000. Now only 10,000 is left out of that 1 lakh, one third permissible limit. So C will get only 10,000 rupees. So this is what the chronological priority rule explains about Shia law. There is an exception to the exact one third rule. So it is interesting to note that the rule of chronological priority is not applicable in cases where under one legacy two or more persons have been given an exact one third of the total asset. In such cases, legatee whose name appears last gets the one third given to him under the will, and the legatees whose names appear prior to him will not get anything. Let me again give you one illustration to explain it clearly. X, a Shia Muslim, he dies, leaving behind net assets worth rupees 3 lakh and a legacy under which he gives rupees 1 lakh each to A, B and C in that order. So one third is the permissible limit for bequest and one third of 3 lakhs is 1 lakh, which is exact one third whatever he has given to A, B and C. So his limit is 1 lakh rupees and he has given also 1 lakh to A, B and C. So here in this case, C, whose name appears last, he will get the entire one third property, while A and B, they will get nothing. So it is just a contrary of the rule of chronological priority which Shias generally follow, because it is the exact amount, it's a match. So here the bequest is treated as an independent bequest with the subsequent revoking the former. The first bequest was in favor of A, the second in favor of B, and the last in favor of C. So legacy in favor of B revokes the one which is in favor of A, and the legacy in favor of C revokes the will which is in favor of B. Hence, in such a scenario, C alone will get the entire one third share by applying the exception which is related to exact one third rule. Shia bequest to an heir. Under Shia law, bequest to heir is valid up to the permissible limit of one third of the property. Consent of other heirs is not required even if the bequest is made in favor of a legal heir. Consent is only required from other legal heirs if the bequest exceeds the permissible one third limit. Otherwise, the testator is free to make a will in favor of anyone, including the legal heirs. Coming to certain distinctions between Shia and Sunni law. The first distinction is under Shia law, bequest in favor of a legal heir up to one-third permissible limit is valid. So, if they only consider this one-third permissible limit, that's it. And up till this one-third permissible limit, in whose favor they want to make it, they are free to choose and they are free to make it in favor of anyone, including the legal heir. However, when we talk about Sunnis, generally a bequest in favor of a legal heir is invalid, even to the extent of the one-third permissible limit, because it will fluctuate the share, which is the Quranic, suppose, as we have discussed in the earlier example, that it will overpass whatever the limit is provided under the Quran. So there can be a disparity. That's why it can be only validated with the consent of other legal heirs. Second distinction is, under Shia law, legatee causing the death of the testator is disqualified if the death was intentional, but not where it was caused accidentally. But under Sunni law, the legatee causing the death of the testator is disqualified, no matter whether it was intentional or accidental. The third distinction is, under Shia law, rule of chronological priority is applicable in case the bequest is in excess of the one-third permissible limit in favor of two or more persons. Under Sunni law, rule of proportional deduction applies in case the bequest is in excess of the one-third permissible limit in favor of two or more persons. So in Shia law, you may or may not get property. It will depend upon the fact that whether your name is reflected in the chronological priority order or not. However, in case of Sunni law, because you are applying the rule of proportional deduction, definitely some share the parties will get in whose name the bequest has been made. No matter, it may be less, it may be more, depending upon how much they have been given, but they will get something. The fourth distinction is that in case of Shia, if the legatee dies before the testator, the legacy will lapse only when either the legatee dies without leaving a legal heir or where the testator himself revokes the will. In Sunni law, if the legatee dies before the testator, the legacy lapses. The fifth distinction is, under Shia law, consent of the heir can be given before or after the death of the testator. Under Sunni law, consent of the heirs must be given after the death of the testator. Sixth point is, under Shia law, bequest in favor of a child in mother's womb is valid if the child is taking birth within 10 months from the making of the will. This is also valid in cases of Sunnis, but the timeline is a bit different. The child has to take birth within 6 months of making of the will. So it is not after the death of the testator. It is, you have to count this, calculate this 6-month or 10 months timeline from the date of making of the will. The seventh point of distinction is, under Shia law, legacy can be accepted before or after the death of the testator, but under Sunni law, the legacy must be accepted after the death of the testator. The eighth distinction is, under Shia law, the will by a person who later commits suicide is invalid. It is only valid if the will is made before taking any step towards committing suicide. However, under Sunni law, a will by a testator who commits suicide later on, it is valid. The last distinction between Shia and Sunni laws is that in cases of Shia where the bequest is of exact one-third of the total property given to two or more legatees under the same will, the last mentioned legatee only will get that one-third of the property. However, in Sunni law, where the bequest is even of this exact one-third of the total property given to two or more legatees under the same will, the rule of proportional deduction will apply and they will get something of that legacy. Revocation of will. A testator can expressly or impliedly revoke the will. It is not necessary to revoke an earlier will. Another will must be made. So, it can be revoked by a clear declaration to that effect. One illustration of implied revocation, let me give it to you. Suppose the testator, he bequests 30 lakh rupees in favor of the legatee, and after 2 months he goes on a world tour with that 30 lakh rupees. So the will is automatically revoked because the subject matter of the will was this 30 lakh rupees, and which has already been exhausted and used by the testator in his world tour. Bequest of life estate. The Cambridge Dictionary defines life estate as the legal right to own and control a property such as a building or a piece of land for the length of time that you are alive. The concept of life estate is permissible in Shia law, but it is not permissible under the Sunni laws. Let me give you one illustration. If the Muslim is belonging to Shia sect, suppose he makes a bequest in favor of Y of his farmhouse for life and after him to Z absolutely. So here Y can enjoy the property till his lifetime, but after his death Z will get the property absolutely. Y cannot transfer the property to anyone as the property does not belong to him, and after Y's death his legal heirs also cannot claim any inheritance right in that property because the right is created only in favor of Y for his lifetime. So therefore, life estate is neither transferable nor heritable. However, when we talk about Sunni laws, and if we take the same similar illustration which we have taken for the Shia Muslims, suppose X makes a bequest in favor of Y of his farmhouse for life and after him to Z absolutely. Under Sunni law, creating life estate is not permissible. Therefore, the bequest in favor of Y would operate absolutely and Z will get nothing. Bequest for pious purposes. A bequest for pious purpose is valid in both Shia and Sunni sect to the extent of one-third permissible limit. The first bequest can be for bequest for faraz, that is purposes which are ordained in the Holy Quran, such as for Hajj pilgrimage. Second is bequest for wajibat, that is not expressly ordained in the Quran, such as charities given on the day of breaking fast. You know, in Ramzan there is roja and all, and charities are given on those days when the fast is, they break the fast that time. So it is known as bequest for wajibat. The last is bequest for nawafil. It is purely voluntary in nature. For example, for building a mosque or a school, etc. Now coming to few interesting questions. Question number one. What is the permissible limit for making a will under Muslim law in general? First is, a will can be made for the entire property. Second is, a will can be made for half of the property. Third is, a will can be made for one-third of the property. The last option is, a will can be made for two-thirds of the property. The correct answer you all know after this discussion today, that the correct answer is option number C, that a will can be made for one-third of the property. Question number 2. X accidentally caused the death of Y. Can X inherit Y's property? So the options are like that. The first option is Sunni, yes. Shia, no. Option B, Sunni, no. Shia, yes. Option number C, Sunni, yes. Shia also yes. And the last option is Sunni, no, and Shia also no. So the correct answer is option number B, that is, in cases of death caused by the legatee and he has caused death of the testator, in such cases he cannot inherit the property, even in cases of intestate or testamentary succession in both the cases. So for Sunnis it's a no, no matter it is accidental or intentional, and in cases of Shia it is yes, only in cases of accidental death. If the death is intentional, definitely it is a no. Question number 3. In which sect is the bequest of a life estate not permissible under Islam? First is Sunni, second is Shia, third option is permissible in both the Shia and the Sunni sect. The last option is not permissible in both the Shia and the Sunni sect. The correct answer is Sunnis, because Sunnis does not permit for the bequest with respect to life estate. Question number 4. When should a child in the mother's womb be born for a valid will in his favor? The first option is within 6 months in Shia, within 6 months in Sunnis from the date of making of the will. Second option is within 10 months in Shia, within 10 months in Sunnis from the date of making of the will. Third is within 6 months in Shia and within 10 months in Sunnis from the date of making of the will. The last option is within 10 months in Shia and within 6 months in Sunnis from the date of making of the will. The correct answer here is the last option, that is option number D, which says within 10 months in Shia and within 6 months in Sunnis from the date of making of the will. Coming to the last question. X, a Muslim woman, dies leaving behind her husband, a daughter and a son. Calculate their shares. So the option number 1 says husband will get 1/4 share, daughter will get 1/4 share, and the son will get half of the share. Option number B says husband will get half share, daughter will get 1/4 share, and son will also get 1/4 share. Third option says husband will get 1/4 share, daughter will get half of the share, and son will get 1/4 of the share. The last option, that is option number D, it says husband will get 1/4 share, daughter will get 1/4 share, and son will get 1/4 of the share. So here the correct answer is the option number A, which says the husband will get 1/4 of the share, daughter will get 1/4 of the share, and son will get the double of what the daughter gets, that is half of the share. Thank you for the patient hearing. Thank you so much.